in our various stations, both locally and worldwide. Thank you for joining us. Also, don't forget that our stations also broadcast. Don't forget that our station and our show is also broadcast live on YouTube. So I want you to immediately go to YouTube, Nathaniel Lee, Legally Speaking, and sign up for YouTube. That's very important that you support our YouTube channel. Today, we are also joined, as usual, by a superstar lawyer panel with the great Vanita Banks out of Chicago, formerly from Indianapolis. We claim her because she grew up here, and she's one of the most outstanding lawyers in the country, masters in tax, and just a brilliant strategist. And also the great Milton Grimes. He made famous the idea of videotaping in the Rodney King case, which led to a change in our criminal justice system. And we saw the evolution of this process up until last year with the Arbery case, and all those cases all gravitated from the use of video footage, which was made famous in the Rodney King case. But in any event, there's a lot of important issues that we're going to talk about today. Also, locally, we're a live call-in show, 317-239-1310, and feel free to call us on our local station. Now, having said that, Attorney Banks, we had some discussions off the record. She had some great updates on these Supreme Court judges. I think she personally knows one of the candidates. Attorney Banks, what about these Supreme Court candidates? Our president say, we will put a Black woman on the Supreme Court. Great. In the history of America, we've had never had an African-American female in the Supreme Court. I noticed up until Thurgood Marshall, it was all white men on the Supreme Court, up until Thurgood Marshall in 1967. So American history has not been one to actually participate in the judicial process at the Supreme Court level. Now on the screen now, we have a litany of all the potential candidates under consideration that our executive producer just put on. She listed them: Judge Childs, Kenyatta Brown Jackson, Leandra Kruger, Melissa Murray, Wilhelmina Wright, Eunice Lee, Anita Earl, and the list is very voluminous. And but I got a confession: I don't know any of them personally, and that's kind of unusual, you know. And the reason that's unusual is I served on the Judicial Selection Committee during Obama, and I just don't remember the ones that got appointed at this point in time. But I know a lot of federal judges. I just didn't know these particular ones. Attorney Banks.
Well, I'm sure, Attorney Lee, and first of all, good morning, and thanks for having me. And what you see on the screen is an excellent group of brilliant African-American female jurists that are being considered for the United States Supreme Court. And by the end of this Black History Month, President Biden is expected to name his nominee. All of these candidates possess the character, experience, the judicial temperament, the intellect, the fairness. They're legal scholars. Any and all of these candidates would be an excellent choice for the U.S. Supreme Court. And historically, as you were stating, Attorney Lee, there have been 108 white male members of the Supreme Court, one Latina member, 4 women, and 2 Black men. And so we are poised to make history with the announcement of President Biden's nominee this month. A short list includes Justice Michelle Childs. She is a member of, she's a U.S. District Judge for the District of South Carolina, and she's been serving in that position since 2010. She is also an expert in labor and employment law. She was a former partner with a large law firm in South Carolina. She is a labor and employment expert, and she was currently a nominee to be a U.S. Circuit Judge for the United States Court of Appeals for the D.C. Circuit, which is viewed as a springboard to the U.S. Supreme Court. She has bipartisan support from South Carolina Senator Lindsey Graham, who was quoted as saying that she is a fair-minded and, quote, highly gifted jurist. She is supported by bipartisan prosecutors in South Carolina, and she is endorsed by majority congressional whip Congressman James Clyburn as well. She's a product of public schools. She attended public universities. She, interestingly, in addition to working at a top law firm in South Carolina, she served in leadership positions at 2 state government agencies, and she would bring a fresh perspective to the court. Other candidates being considered include Ketanji Brown Jackson. She is a former clerk for Justice Breyer, whose position is, who announced his retirement and whose position is being filled. And she is currently a DC circuit judge. And Leandra Kruger is currently a member of she's a California Supreme Court justice as well. And so other candidates include Sherilyn Ifill, who I'm sure you know, Attorney Lee and Grimes, who recently announced that she's stepping down from the, is it the Lawyers Committee? And I'm
Yes.
sure that if I got that wrong, that callers will be calling, and she's one of the candidates as well that's being considered.
That's great. Now, before Attorney Grimes, let's take this caller who has a comment about this. Hey, caller, you have a question or comment for Legally Speaking show today?
Yes, how you doing, brother? How you doing, brother?
So, do you think that Biden made a mistake by saying that he wanted to select a Black woman instead of just simply selecting one and then moving forward?
I agree, long as she's not, long as she's the total opposite of Clarence Thomas. With all the new reports that came out about Jeannie Thomas this week, all that political activism and his texts and conversations with DeSantis down there in Florida, well, that's the last thing we need. It's someone who harbingers the same attitude he has, as Jordan and Hurst would say, under the guise of black skin. Don't want that. We got enough of that going on, so we need a direct buffer, a clear and direct buffer to Justice Thomas. Know that this person is going to be a direct buffer. Because going back to Michelle Alexander's seminal work, The New Jim Crow, and Michelle, in one of her main thesis statements throughout the book is that how the Supreme Court has been complicit and downright shameful over the last 30, 35 years, protecting the rights of Americans, especially the rights of minorities. We just see what happened in Minnesota again this week, the no-knock warrant killing a gentleman sleeping on the couch. So I brought these cases, McCleskey, Kemp, Armstrong, United States, California, Acevedo, Ohio, Robinette, but the one that sticks out is Terry versus Ohio, when Justice Douglas in his dissent said that granting police greater power than a magistrate judge is to take a long step down the totalitarian path. He objected to the notion that police should be free to conduct warrantless searches whenever they suspect someone is a criminal, believing that the dispensing with the Fourth Amendment's warrant requirement risks opening the door to the same abuses that gave rise to the American Revolution. What's your thoughts about that? Thanks, Mark.
Wow, Attorney Grimes, that's a lot in your bailiwick.
Yeah, well, he started off with stating something about one of these jurors being similar to Clarence Thomas. Did I get that correct? I couldn't understand all that he was saying until I got used to listening to him. What was that comment? I'd missed
Well,
it.
he basically was saying skin folks, not kin folks. He was talking about Clarence Thomas' wife, who is apparently got text with all these right-wing conspiracy theorist people. And so he had a problem with the fact that Clarence Thomas is making a decision on these cases. At the same time, it's clear that his wife is an advocate for the worst right-wing conspiracy theorists in the country.
I got it. I probably agree totally with them on that particular point. But just talking about the justices in general, I'm looking for and hoping for diversity in experience, which hopefully brings about diversity in ideology on the bench. And I like the fact that Ms. Jackson, candidate, I shouldn't say Miss Jackson, Judge Jackson. Can you hear me, Nate? I get the
Yes.
okay.
Yes.
That she is a former public defender, I believe, and one of the few, if not the only one, that would be coming from a criminal law background, which I think you both would agree that in order to make the court see and have the exposure of diversity in the law, we would deeply appreciate not only just an African-American judge, but a judge with some criminal law experience. I think Marshall had some criminal law experience when he arrived, but Clarence Thomas, all of these new appointments, Kavanaugh, none of them have had criminal law experience as that judge has had. And I think it's needed on the bench. I agree with this brother here. Really, in reality, we've only had one African-American Supreme Court justice, one who had ideology and philosophy and concern about the rights of African-Americans. Because Thomas surely doesn't have it. And so we do need someone who will take on the issues that involve us as a people and explain them and try to ensure that we receive justice in this very, very complicated makeup of America. So that's my hope for it, that we do get Justice Jackson on this bench. I guess I have to be honest about that because of her diversity and her diverse experience and different experience than others. I don't have anything against cooperative lawyers, Vanita. I know that's a world that you're familiar with, but I just think that we are better served by diversity on the bench.
Well, before we go to
absolutely, and I think absolutely, and I was just wondering, Attorney Grimes, do you have any perspective on Justice Leandra Kruger, who's currently on the California Supreme Court?
Nothing other than she's respected, she's intelligent, she's bright. Hey, I wouldn't doubt that all of them are highly capable, much more than I, of looking at these laws and dissecting them and issuing out rulings that are deeply thought of. I'm just saying, Ms. Jackson, Justice Jackson brings some experience I don't think the others have that I know of yet.
Hey, before Attorney Banks responds, let's go to line, take one additional call. Okay, caller, you have a question or comment for us today?
Hey, good morning.
Good morning, sir. What's your comment today or question? Okay, can you speak up a little bit louder, sir? What's your question or comment for today? I apologize, I can't hear you.
Can you hear me now, Nate?
Yes, sir. Are you on a speakerphone or what?
I turned it off.
Okay, go ahead. What's your question or comment?
I have a real problem. Clyburn's pick. I know that he helped the president get elected and everything, but she's a corporate lawyer. She represented, did a lot of work for corporate firms. And in my opinion, she's a Clarence Thomas in disguise. Should rise up to everybody know that she is good with Judge Brown or that other lady from California somewhere, but definitely not that South Carolina judge. No way, no how. But thank you for taking my call.
But the problem though is that you can't make a broad-brush categorization like that because lawyers of all kinds make a living. So, for example, if I did a criminal case and I represent a person who was a child molester, does that mean that I applaud that? Well, hell no. We're advocates. So the fact that she worked at a law firm, I don't think that disqualifies her at all. I think that she also was a circuit court judge there in South Carolina, and she had rave review, particularly from the minority community. So never take a single incident and try to use that to disqualify. If you use that standard, you can come up with an excuse to excuse every candidate, particularly candidates of color. I think that in order for her to get a job with a large law firm, she has to have excellent academic credentials. She had to be exceptionally gifted lawyer. So I don't think that that's a negative. I deal with lawyers from all sorts of law firms, and whether they're lawyers that are in big firms that are Trump supporters, and there's lawyers in law firms that are Biden supporters. So in other words, it goes both ways. So the fact that she worked at a large law firm, that's not a negative, that's a positive in my mind. Attorney Banks? Did we lose her? Okay, we'll go to the next caller then. William.
Hello?
Oh, okay, Attorney Banks. Okay, you came back.
Take the next call. Take the next call, Attorney Lee.
Okay, Mr. William, you have a question to come in for us today, sir.
Yes, Mr. Lee, I have a question from diversity. The Supreme Court is supposed to uphold the laws of the land. In the business specific example of what I'm asking the three that the Supreme Court dealt with. How important is diversity in choosing of court?
Well, that's an excellent question. Attorney Grant, what he said, the caller says that since the Supreme Court is the highest court in the land and they make the laws of the country, how important is diversity on the Supreme Court?
Oh, brother. Look back at when they had all white men on the Supreme Court and just think about the decisions that were made during that time. I guess I will use as a comparison a Supreme Court that I have some familiarity with, and it's the state Supreme Court in the state of Washington, where June the 4th, 2020, they issued a manifesto or a statement saying they recognize that their court has been discriminatory and racist in decisions that had been issued out on minorities, especially Blacks. And they have set out to undo it. And they have reversed some of their decisions. So that's just an example that I will use for you that's in front of us, that has been acknowledged. I think diversity adds to it that some assurance and some belief that you and I will be represented on that court, as opposed to having 7 justices on the court. I mean, 9 justices on the court, and they're all white men. When you put a woman in there, they got to be careful about their decisions as it relate to women's rights. When you put an Asian on there, they're going to have to be more conscious about their decisions as it relate to that ethnic origin rights and benefits of living in this country. So I think diversity, and if you had all women, it would be the same for issues affecting men. So I think diversity is necessary and it is very effective, and we need it in all of our institutions and especially our Supreme Court.
Attorney Banks, why is it important that we have an African-American female on the Supreme Court?
To bring that, again, diverse perspective and view to the Supreme Court. I wanted to pick up on Attorney Grimes' point with respect to Judge Ketanji Brown and her experience, and she's among the leading candidates to succeed Justice Breyer. She has already, by the way, successfully navigated a Senate confirmation process when President Biden elevated her from the federal district court in the District of Columbia to the powerful U.S. Court of Appeals for the D.C. Circuit. She was confirmed by a 53-44 vote, and all 50 members of the Democratic caucus voted for her, as did 3 Republican senators, Susan Collins, Lindsey Graham, and Lisa Murkowski. She clerked for Justice Breyer, as I mentioned before. She's born in Washington, D.C., grew up in Miami. She graduated from Harvard College and Harvard Law School. And she's held several jobs early in her career, including she was a member of the U.S. Sentencing Commission, as well as an assistant federal public defendant in Washington. And again, that diversity of experience, as Attorney Grimes stated, would bring, a fresh and perspective to the Supreme Court.
Well, there's one thing that I need to give a big shout out to, that is the Biden administration. I just feel very blessed to be in America now, to be engaged in a conversation about putting an African-American female on the Supreme Court. Never in American history has we been able to have a conversation like this before. And I think it's historic that we even talking about this, because as Attorney Grimes pointed out, our court, Supreme Court, at one time openly supported segregation and slavery. So now we see a radical departure. The fact that we can have this discussion, and something else that was important is, on a side note, in American history, for the first time last year, we had 6.7 million jobs created by this current administration. So I give them great credit for making some tremendous progress in America. This is historical, folks. The fact that we can have this conversation this day and time, I just feel very blessed that we're able to do so. So I hope that we continue to recognize the importance of voting, because the fact that we can have this conversation this day and time, believe me, it's historic. Now, the other issue, though, how difficult do you think the confirmation process will be? Got any comments on that issue? I noticed that Ted Cruz made a very racist comment. It was so racist, I don't want to repeat it, but the point is that somehow, and then the senator from Mississippi, who himself was a product of racial discrimination, he got appointed to every position because of affirmative action, being white male. No qualification that qualified him besides for the fact that he'd just been the relative of somebody and got appointed. Then he got elected a couple of times, but their whole idea was, Cruz said, well, it's discriminating against whites in America. Well, it was an insult what he said. No time in American history did he complain about the fact, and he was a Supreme Court law clerk, that there had all been all white males up until for the first 200 years of the Supreme Court. Never complained about that. The fact that you have one African-American female being considered, I thought was the ultimate insult.
I can't think of his name. He appeared on Don Lemon's show this past week. He's a Republican, does some talking head stuff on CNN. He accepted the fact that we're going to have an African-American Supreme Court justice, female, because it's time. And that's an accepted position. But I don't expect them to just lay down and accept whoever President Biden appoints, because that take away from another target that they can make false allegations against about how racist it is and how unfair it is and how it's given special treatment to African Americans, all of the arguments they have levied against us throughout the recent history when we've tried to step forward. So that's a battle we're probably going to face, Nate. I hope that those Supreme Court justices are willing to or capable of surviving it. But I don't expect it to be a layup for President Biden, Nate. That's what I expect. Now, what it's going to be, I don't know what they're going to bring out of the closet or the grave to attack these women with, but you can expect something.
That, I agree, will certainly be the case. I was happy to hear early comments from Senator Manchin stating that the president has a tremendous number and amount of qualified candidates, and he praised Justice Michelle Childs as being, quote, extremely qualified. So if the Democrat 50 senators could all hang together, right, then President Biden's nominee, if there's a 50-50 vote, we'll see another historic moment when Vice President Kamala Harris casts the tie-breaking vote. But I agree, we've heard a lot of hypocrisy, offensive and insulting statements this week by several white members of Congress, including Senator Cruz, playing the, quote, reverse race card. And as you know, Ronald Reagan committed to nominating a woman during his term, and most recently, former President Trump committed to nominating and did nominate a woman. So fairness dictates an expedient confirmation process akin to that of Amy Coney Barrett's confirmation process.
When you get another chance, Nate, as I believe you often do on a weekly basis, when you get another chance to talk to Vice President Pence, maybe he will tell you his views about this now that he's speaking close to the truth on some issues.
I think you're mistaken. You mean Kamala Harris, right? That's the vice president now.
No, I'm talking
You
about
know,
the vice
No,
president.
he's talking about Pence and his statements this week, disagreeing with President Trump on January 6th and the power of the vice president to, quote, overturn an
Yeah.
election.
And I'm looking at how
He broke.
the congressional the people, the Republicans are gently dealing with his position now, Vanita. They don't want to speak out against him, and they don't want to strongly support what he said, and they seem timid about it.
well, that was the biggest political bomb of the week. You had the Republican National Committee that voted to censure Adam Kinsley and Liz Cheney. It was historic because they're saying that politicians who tell the truth about what happened in terms of an assault on democracy, they're a traitor to the Republican Party. And that's not the Republican Party that I knew growing up. And that's a radical departure from what the Republican Party ever stood for. It's just so bizarre. You know, I've been a Democrat, but man, this type of Republican Party is dangerous.
It's scary. It's scary,
yeah.
Nate.
The fact that they're saying that, you know, historically speaking, let's look at what happened. In the down ballots, in the congressional race, the Senate race, the governor's race, Republicans actually scored victory. They're on the same ticket as Donald Trump. So in those 5 critical states Trump lost, Republicans actually did pretty well. And so even in those Republicans that got elected to the House or the Senate with Trump on the ballot, they themselves had the temerity to say that there was something corrupt about the election. Then why in the hell did they resign? You know, the whole thing is so insulting, that the fact that you had this assault on democracy. But thank God that Mike Pence is from Indiana, and Mike Pence is not I think that he has a fundamental problem with this chronic lying. You know, I think at some point in time, he's just saying enough is enough. And when Trump keeps throwing him on the bus, it suggests to these people, they were saying, hang Mike Pence, that somehow Mike Pence is a traitor to Trump because he did not try to go along the scheme to overthrow American democracy is insane. It's insanity.
Yeah,
That's what we're dealing with now.
And for the public, I was teasing Nate about having a weekly dialogue with Mike Pence. I know better. I just wanted to get his comment about his brother.
Former governor. Yeah. Attorney Banks, what you were saying, I apologize for cutting you off.
No, I wasn't. I was just saying that, yes, Attorney Grimes, I picked up on Attorney Grimes' joke relative to your weekly discussion with Vice President Pence.
Yeah.
Both hailing from the state of Indiana.
Hey, a third issue that been troubling to me is that maybe you guys can explain this to me. Ahmaud Arbery was brutally murdered down in Sarth, Georgia. I talked to his mother early on after that occurred, and I've been following that case. And recently, it's set to go to trial in the federal court this week on a federal hate crime. Both the father and the son pled guilty, and they were going to get 30 years in prison. And then the family objected to the guilty plea. And we had some off the record discussion about this, Attorney Grimes and I didn't understand this process because anytime when they did the jury trial in the criminal case, the defense lawyers raised all types of objections and they made all types of motion. And they threw everything up against the wall, but every now and then, it only takes one esoteric issue to get a case reversed. Now, most of the time, about 90-some% of the time, cases are affirmed on appeal. But there's a slight possibility that any case can be reversed. So I was thinking to myself, if they were to enter the guilty plea, at least we could put this behind us. But they objected, saying the federal penitentiary is too soft of an incarceration. And therefore, they want them to serve their time in state prison system. And they objected. And I was surprised that the guilty plea was rejected by the judge. And so, I don't know, what's your thought?
Well, if you're asking me, I still say that 30 years in federal prison, y'all, it is not a holiday. And they have one down there if you reach the category for safety and security in our nation, and they put you underground down there in Colorado. My understanding is that is not a trip to Disneyland. That's serious time. So coming back here to the state case, yes, Nate, I've had a death penalty case where my client made a confession that he had committed the crime. And I was fighting it because one of the reasons were I wanted to show he was mentally ill, but because of it was a 9-year-old child who was the victim, and the jury just would not accept him being insane because of all the other things he did. But that case was reversed on a motion for new trial by me because the jury had discussed my background on a couple of other cases that I had done that was high profile dealing with mental illness. And we were granted a new trial in a death penalty case where there was a confession by my client, et cetera, et cetera. So I had to do that trial a second time. So here we have a high profile case dealing with the issue you're talking about with Aubrey. And there is a likelihood of jury misconduct to be found, to be gathered, that could reverse that conviction, no matter how clear the facts are to everybody. But that's the system. That's the system we have. And I endorse that when you have those issues. So there is a possibility that that conviction could be overturned and they could receive a new trial for some reason. But a guilty plea stops all the bickering and expenses of trial. And 30 years is a long time, folks. I'm not an advocate of the death penalty, and I'm not saying that 30 years is enough. I'm just saying it's a long time. So that's my position on it.
30 years for the father, Milton, would have been the death penalty. He was 6 to 8 years old.
There
So
you go.
30 years added on to 6 to 8. And I think in federal, what you do about 80% of your time or 75%?
85%.
Yeah, so 85% of 30 years is what, about 24, 25 years. That's the death penalty.
Right.
You know, he would die in the federal penitentiary, no matter what penitentiary is. And that's why when I saw what the lawyers were doing, and I don't know, I guess you got different tactics and stuff like that. But from my perspective, and looking at this case through a lens, I thought that the plea agreement guaranteed closure to this case. And because trials is a lot of emotional stress for everybody,
Right.
the victims, particularly for the victim and, you know, the mother and stuff like that, to go through this again, this horrific evidence of your son being murdered. And then they're going to talk about the racial history of these defendants. It's going to anger you. There'll be a lot of sleepless night. And, you know, between the state and the federal, let those guys die in prison and go on to the next case. And I thought.
That's what my position is.
Attorney Banks?
Well, I think that the family understands what this trial will entail, and it's my understanding that they rejected the plea as a matter of principle. And so the question that I have is whether or not, apparently, the judge has complete discretion in these situations.
Judge has discretion to accept a plea or not accept it because of what he feels may or may not be proper terms of it. Yeah, they have that discretion.
And was the plea presented only on behalf of Travis McMichael?
Both. It was both of them.
Both of them. Okay.
Yeah,
Travis
father
and
son.
Michael? Okay. And the son? Okay.
Yes. Well, here's what about this? And I don't know this federal court sentencing guideline stuff because I don't do federal criminal cases. But I was thinking to myself, if they entered the plea agreement, can the judge? I thought, generally speaking, when they do plea agreement, they put ranges of sentences, but the judge could actually alter that slightly.
Yes, that's true. But I think the judge could be, they can appeal this judge or take a writ on it, the judge refusal to accept this plea, unless he can articulate some compelling reason why he wouldn't accept this plea. They may override his rejection of this plea, guys.
What about evidence rule 403? Now that they enter into a written plea agreement of guilt to the charges, would that plea agreement then be admissible in the criminal case that they've signed, say they were guilty?
No, I don't think so, Nate. No, that was in that's like in mitigation or in mediation where evidence come in, can't be used against a person in a subsequent trial if you don't agree or settle the case at that time. Those were discussions that were in settlement and in negotiations. I don't think they can be entered against the defendant.
And of course, I can't speak.
Go ahead.
And of course, I can't speak for the family, but I think this is maybe part of their quest in continuing to seek justice for their son, to continue to show to America that his life mattered. And just kind of analogizing to Emmett Till's mother, who forced America to look at the brutal atrocity and murder of her son. It may be the family's quest that America face this murder of her child, and that they proceed forward with a trial resulting in a verdict that these men committed a federal hate crime.
Well, Vanita, I would appreciate the family being that influential in our justice system, but my reality of it is that the victim impact statement does give the family an opportunity to express themselves and release their anger and vent their anger, but the judge make the decision. I argued a couple of years ago against the sentencing of a police officer who blinded my client and lied about what had happened and accused her of attacking him, and the cam in the vehicle showed he had lied. And we settled that case for the family and that client, and they prosecuted that cop and had a hung jury because 2 jurors just wouldn't convict a cop in the face of the truth. And the DA presented the case for a second trial, and they got a mistrial on that because of an evidentiary issue, which wasn't that relevant, but they should have continued with a third attempt to try it. But the DA used that as an excuse to settle the case. And they ended up, rather than this guy getting 4 years in prison for blinding her in both eyes for the rest of her life, illegally abusing her civil rights, they gave him a misdemeanor and probation in no time, even though the family and I argued and expressed our dissent from that. But the judge went ahead with the plea. So the victim impact statement does not dictate what the judge have to do.
Wow, that's critical. Well, there's one thing too, on a corollary type case, I just thought about something that you said about the evidence. The Bill Cosby cases were very instructive after I thought about it. I'm not a criminal lawyer, but his case got reversed, I think, in part because he had the deposition that was sealed and they had promised by the prosecutor. And so even though they put in evidence that I thought was clearly not relevant in the 403 of the rules of evidence, they put in statement of uncharged crime, the thing that happened 30 years with some other victim, they got that into evidence, which was very compelling evidence. but the case was reversed on this promise made by the former prosecutor.
Not
And
to-
so after I thought about that, that makes sense. But, you know, I got to think that then when they make those plea agreement, that tells me it's not likely that those defendants will take the stand in the federal hate crime, because I noticed that they pull off stuff off the internet. One of the big mistakes that a lot of people make, they put all their information on the internet and not realizing that is a permanent record. And so with these guys, apparently they had some racial hate stuff on the internet that was not introduced in the state crime, but will be introduced in the federal crime.
Mhm.
So that'd be interesting following this trial. Now, the problem though is that I don't think that this trial will be televised in the federal court. I'm not aware if the federal court's televising trials yet.
They
Is
don't.
that right?
That's right. That's right, Nate. Not one federal court trial that I know of. No.
And we may have to spend more time on this next week, but in contrast, we saw former police officer and convicted felon Jason Van Dyke released from federal prison after only serving about half of his 6.75 year sentence.
Mhm.
And that resulted in an outcry and protest across Chicago. And you'll recall that former officer and convicted felon Van Dyke was convicted of second-degree murder and 16 felony battery charges for shooting and killing 17-year-old Laquan McDonald, and shot him 16 times as he was walking away, and posed no threat to former officer Van Dyke.
You just reminded me of something I must mention, and that is 137 shots. Netflix showed it a couple of weeks ago or so about Cleveland, Ohio, where they shot at this couple 137 times, and the officer ended up jumping on the hood of the car and shooting approximately 40 sometimes in the windshield, so he was in fear for his life. It is the most horrendous finding by the trial judge who tried that officer and said, yes, I believe he was afraid, and found him not guilty. I just thought about that when you were saying that, Vanita. It's a show that I think is a must see. It's a documentary of it, of that killing.
That's terrible. I forgot about that case. Yeah, I forgot about that case. That was an insult, and
It was.
that's just tell you the power to vote is sacrosanct. I mean, they should have voted that guy out of office immediately. They
Right.
should have filed for judicial misconduct, because obviously that no way that he should have reached that decision. But it just shows you, based on what Attorney Banks just said about Van Dyke, you shoot at this kid in the back 16 times who posed no threat. You get 3 years in prison. And we're not even sure he served the 3 years. I thought that part of that was home detention. Was that all incarcerated?
It was all incarcerated.
Yeah, so did he
was
get to
released
keep
Thursday.
Did he get to keep his pension? I saw the police union was supporting that guy still. It's just sickening to me. They support a guy that they all see committed murder. And you know, I was troubled by that, quite frankly. You know, that's not.
And again, this verdict was before the George Floyd verdict. And again, he was charged with second-degree murder and aggravated battery.
Well, see, the problem that I have with Illinois is that they don't allow you to record police officers. And so that's one of the few cases you've seen video footage, because they don't permit the citizens. I mean, it's a little bit insulting what some of the laws, they need to change that.
Well, we don't get the benefit of the coach of the Patriots congratulating a coach on a job that he got that he didn't get because there's the backdoor decisions made before the issue comes to them. We don't get the benefit of that a lot of times in the justice system, but it happens.
What sound like a final comment, dude? So you want to talk about the NFL? So make your final 1 minute comment about that, because we at the end.
No. I just like to hit you every time I get a chance, Nate. That's all. But my final.
It's a big issue. The NFL and hiring practices. 70% of lead African American, one black coach, 32 teams, no black owners. I get that. Your comment about it?
It's appalling, because the Rudy rule is just a facade. It's just a fake confidence builder. Okay, y'all, we're going to interview a black coach before we hire, but we decided last week who we're going to hire. And it's not settling the problem. It reminds me, like I said earlier to you, Nate, of the statue there I saw in Indianapolis with the master sitting on the horse and a slave down on his knees with chains on him, looking up to him. We got to attack this injustice to our people everywhere we see it. And if it's in the NFL or the NBA or baseball or in corporate America or in the justice system, we got a job to do.
Attorney Banks, your closing comment?
Well said, Attorney Grimes. Diversity matters, and the perspective of a extremely qualified, of course, that goes without saying, black female jurist on the Supreme Court matters, and it matters greatly. And the time is now for the inclusion of a brilliant African-American female jurist on the United States Supreme Court.
My closing comment has to do with the fact that I love February for one reason. I hate cold weather, but I love the fact that they recognize Black history as an important process in American history. There have been so many attacks with this critical race theory and things like that. And but Black history, I just love the fact that I get these historical emails and texts every day about all the historic achievement about Blacks in America, all the things we've done and the accomplishment. And I'm so proud to the fact that we're able to celebrate this history each February. It gives me something to do other than look at the snow and ice outside of my house. But the second thing, though, is that I'm so happy that some of these critical issues are being brought to the front. I was happy the fact that the Arbery verdict and all these verdicts, we're on a winning streak now in the court system. It seems like the issue of race in the court system is being addressed in a lot of cases more so than I've seen during my last 41 years of practicing law. And I'm so happy to see the fact that cases like Arbery and Laquan McDonald end up being guilty verdict for the offended folks. Well, thank you for the justice system. And finally, hats off to Indiana Supreme Court. We have a new system here, dashboard. There was some amazing technology. We skipped into the front in terms of technology into our legal system. We have one of the most modern systems now in case management. Thank you very much. I'd like to thank each and every one of you for listening to our show each week. I'd like to especially thank our superstar panel, Attorney Banks and Attorney Grimes. Thank you very much. And next week, we'll join you once again. We'll talk about another exciting legal issue. Thank you. May God bless and keep you.
Right.
Stay safe, everybody.
I got to run. Okay, bye.
Thank you very much.